thank you very much for the kind introduction, and assessing the assessments was the topic for the next hour or so. I've had the intro, so I wanted to just say I'm coming at this from a data protection lawyer, compliance data protection officer point of view. In my day job, I am a solicitor advising organisations of all sizes on data protection compliance, not just in the UK, but in the EU and further afield. I'm also a data protection officer for one or two organisations. That gives me a different view of complying with the law. We are often in organisations that I'm involved with having to do data protection impact assessments or privacy impact assessments to work out what is the risk to the fundamental rights of individuals with what we are doing, whether it's monitoring in the workplace, whether it is using AI, whether it is outsourcing large volumes of data, etc. What I've discovered over the last few years is that doing the PIA or the DPIA leads you to step out of the process and do other risk assessments. So I've just put on the slide here, what are the values of the other assessments that you might be coming across? And when I started this concept of assessing risk assessments, it was not long after the GDPR came in 2018, and we knew back then that we had got to do privacy by design assessments. We knew we had to do legitimate interest assessments if we were relying on legitimate interests as a lawful ground for processing personal data. But fast forward to 2025, and we're now having to think about assessments for online safety, AI, cyber resilience, supply chain management, and then I learned within the last few days, fundamental rights impact assessments. And in a meeting I was in this morning, looking at another paper from the government, they are saying that we need, when we use new technology, to think about accessibility risk assessments. Is what we are creating disadvantaging sectors of society or those with audiovisual impairments, etc., etc.? I found it quite amusing that the working paper from DCIT that had been sent out that I was looking at started a PowerPoint with white text on white background. But you couldn't make that one up. What I've learned as you do these assessments is that it's a great data governance process. As Steve was just saying, security is integrated with other areas of compliance. So this group is not just about information security, it's about other regulatory requirements, it's about cyber, it's about AI, it's about privacy. And so what I wanted to do in this talk was to say how we got to where I think we are today with a complex requirement to do assessments for different risks. And you might, in one project, be having to look at several risks in the same process. Now, we all think, and indeed the media will tell us that, and indeed the Vice President, J.D. Vance, will tell us that EU has over-engineered everything by the wretched GDPR, and it's us that is the cause of all of this dilemma. Let's not forget that California has got a strict requirement for when risk assessments are needed to be done with people's personal information. And I've just listed on the slide here, when you're selling or sharing personally identifiable information or personal data, as we'd call it, you need to do an assessment as to whether that impacts on the fundamental rights of individuals. And I stress that word, fundamental rights. It's interesting, again, that the media focuses on the GDPR as being something around protecting personal data. But when you look at the small print, it is about protecting not only personal information, but also the fundamental rights of individuals. So human dignity, human rights, equality, and a whole range of other things. And it's interesting that that is where we differ, for example, with the US in general, is that the US focuses on privacy. And we don't focus on privacy, we focus on the protection of personal data and the rights associated with it. Without going through the rest of this slide, I would also say that if you looked at the law in Japan, or if you looked at the law that's in draft again in India, or South Africa, or Brazil, or Chile, or Indonesia, or Singapore, it's about personal information and rights. That's an interesting starting point, and I will keep coming back to it. So it's not all about the GDPR. There are plenty of other countries in the world where assessing privacy risks or the risks towards the rights of individuals is important. Indeed, privacy impact assessments that predated data protection impact assessments started in Canada. The Canadian regulator, Anne Cavoukian, came up with the notion of privacy impact assessments and indeed privacy by design in about 2010. And at the risk of just going off script for a moment and telling a story against myself, when Anne Cavoukian was in London speaking at an event, she let me know she was coming into town, and I said to my wife, it would be lovely if she would come round to our apartment overlooking St. Catherine's Dock and we could do afternoon tea. So indeed, she did come with one of her other officers from the Federal Commission in Canada, and we treated her to afternoon tea and indeed to some champagne. The champagne went down really rather well with her, and at one point she turned to her sidekick and said, "We're creating advocates for privacy by design. We don't have a champion in the UK, so you can be the first one." So I have this certificate from her to be, you know, a champion for privacy by design. Privacy impact assessments were how we managed the risk of impacting individuals' rights. Then we got the GDPR, and we ended up with data protection impact assessments. And what are they? They are a management tool that help organizations identify, assess, and minimize privacy risks when processing personal data, whether you're implementing a new system or using new technology or using new processes. It's a risk management tool that, if it's used at the start of the process, enables you to stop going in the wrong direction. It's like drawing a line in the sand and saying just before we press the yes button, should we? And an awful lot of managing the risk is also in the back of my mind about ethically, should we be doing this? And if you look at AI, I think that is a critical assessment that you would make when using AI. Is just because we can doesn't always mean we should. Let's just take a breath and make sure that we understand the risks and manage the risks. So equally, DPIAs are a good backward-looking tool. It might be that you, as a compliance officer, discover, as is often the case, that somebody in the organization has gone ahead and done something without consulting you, and you've only now just learnt about it, and you should still do the risk assessment, because from my experience, when things go wrong and the regulator investigates, if you have not done anything, you are in deep trouble. If, however, you can produce something that says, we did an assessment, we did not make this decision lightly, even if the regulator does not agree with you, what happens next is better than having got no audit trail at all. So it is a process of identifying risks and solutions, not just producing a report. Every day right now, we see something on the news or the media about assessing the risks of children using social media, engaging online, etc. I've, for years, done work for clients in the computer game sector. That's sort of how I got started with data protection back in '83. At the end of the 70s, I started to act for early games companies. I discovered with one games company not so long ago that because every product they produce requires a risk assessment, they've now simplified the process by having a template that is pre-completed. And all you do is sign it, date it, and put it in the bottom drawer. That is not a risk assessment. We do a DPIA to show that we are complying with the law, but we also do it to protect individuals and that human dignity, human right, etc. But we also do the DPIA to protect reputation. When it goes wrong, that's when you realize, with hindsight, I wish we had done something else, because now our company's name is all over social media. We've now got an investigation by the regulator. None of this makes profit. It's going in the wrong direction. I wished we'd done something. It's also an early warning system, when used properly, to just alert the business to the risks associated. It also shows that you put privacy first. It also informs your decision-making about how we manage the assets, how we govern the data, etc. Who should be involved in the DPIA? Chief Privacy Officer or Data Protection Officer, if you have one, or it's the privacy team, whoever manages data protection. And then inevitably, it should be legal, compliance, other stakeholders in the business. This is a new tool being used by HR. Let's say you're using a new psychometric testing product supplied by a vendor that includes artificial intelligence. It's HR that are driving this, but also IT should be in there, so should legal, because the risk is the AI might cause somebody to be discriminated against if it's not trained properly, etc. Do you appoint an overall project manager? I often find in the in the charity that I'm involved in, where I am the external DPO, I am the ultimate signatory. I take the liability for signing off when all has been completed. And obviously, we need to work with the information security team. And if we've got other parties helping build the product, those should be involved as well. We need their input to understand what are the risks, how we're managing the risks, and so on and so forth. The law, the GDPR, mandates that we must do a DPIA where we are using new technologies and where there are high risks for individuals' rights. And if you are an organization that has a data protection officer, that DPO has to be allowed to consult with the regulator if they believe that the process is not going the way it should be going. So large organizations really have to recognize the DPO is like the internal whistleblower. And you can't cut the DPO out of the process. I had an insurance company client here in the city where the legal counsel at GDPR time was also made the data protection officer. And he said to the chief executive, I cannot be both. I am conflicted. I have to be independent as the DPO. My role as the general counsel is to protect the shareholder value and the board. I cannot balance both. The chief executive would not allow him to appoint somebody else, so he ended up leaving and then presumably seeking compensation for constructive dismissal. So DPO is a big role. There are specific things in the GDPR that says where you must have a mandatory DPIA used. And I've just put on this slide here, systematic and extensive evaluation of personal data based on automated processing that may have an impact on individuals. When this was drafted back in the day, this was not anticipating AI. But you look at that wording, and that is what we talk about when we're using artificial intelligence. Where we are processing on a large scale special categories of personal data, health data, genetic, biometric, and or criminal convictions data, which for some organizations that will be another trigger. And then, of course, if you happen to be in government and you are monitoring data in publicly accessible areas because managing highways, etc., there's an issue. But if you happen to also be the manager of a shopping mall and you have cameras all around, you are caught by that as well. So those are just three in the law, but then equally, the GDPR allows each data protection authority in Europe to mandate other areas. The whole idea of GDPR was that it was to be a level playing field. In fact, it isn't, because inevitably countries like Spain, Germany, that are more protective of the rights of employees have more areas where you have to do DPIAs where you are monitoring employees in the workplace using CCTV, etc., etc. So you have to be careful on a EU-wide basis that it is not a level playing field. I've just put on this slide some of the areas where the ICO says you need to do DPIAs, where you are using genetic data, where you're doing data matching, where you're doing tracking, where you're targeting children or vulnerable persons, where you're using innovative technology, where what you are doing could deny access to a product or service, and that might be accessibility issues. Any large-scale profiling and biometric data. Certainly, the ICO has now said you must do a DPIA where you are going to use AI. The process is usually a 6-step process. It's these things. First of all, do we need to do a DPIA? I'm happy to share this with anybody that wants to follow up with me, but I have what I call a pre-DPIA screening form. It's 2 pages. It's about 20 questions. And it's basically going at a high level, what is it we're doing? Why are we doing it? What are we hoping to achieve? Is it new technology, or are we using same technology but a different vendor? Are we using basic personal data or large volume special category data? And the more no you get, the more likely you are at the end of 2 pages to say, actually, this is low risk. We do not need to do a DPIA, but at least we have got something that shows we talked it through, we walked it through, and I would still have that signed off and put in the proverbial bottom drawer. Should you, I don't know why, oh, I see.
Loop back.
Should you have to do a DPIA, then I would start to describe what are we doing, where are we getting the data from, why are we getting the data, how sensitive is the data, what are the volumes of the data, and so on and so forth. And then what are the privacy risks associated with what we intend to do? And every risk you identify, there's got to be a solution. So you're trying to then minimize the risks, assuming that the end result of your form, your discussions, etc., is that you feel that the risks are managed and you decide we should still go ahead, we can justify going ahead, then we need to get it signed off. And then the bit that often is forgotten is it's not actually put it in the proverbial bottom drawer. This is a living, breathing process, because if you're doing this right, and you're doing it at the start of a project, it could be 6 months before the system is deliverable. And you need to make sure that during that 6 months, you are ensuring that what's been agreed is going to happen is happening, that there isn't function creep, that there isn't somebody going off in a slightly different direction. When you look at the information flows, so point 2 of the process, what are we getting and where are we getting it from? You will start asking yourself, and what is our legal justification for collecting this set of data? At that point, you may step out, as I call it, from the process and say, well, we're not going to rely on consent. We're going to rely on legitimate interests. If we're relying on legitimate interests, we need to do a separate assessment at this point to say why we believe our business interest is not outweighed by the rights of the individual. So suddenly your DPIA has now got this other bit, the legitimate interest assessment. When we think about where is the data going to, if we are transferring the personal data out of the UK or the EU to another country, like the US or Japan or Israel or South Africa, do we need to do an assessment as to the risks or the adequacy of the country that is receiving this personal data? And the answer is yes. So you end up doing a transfer risk assessment. In some instances, it may be a very simple process, because if you're transferring personal data from here to Japan, Japan is deemed an adequate country. End of story, fabulous. But if it's going to China, it is not adequate. So how are we managing the risk? So now we've already got 2 other assessments that we are doing during this process. And we might find that we're also having to deal with privacy by design or privacy first. And again, we possibly step out for another type of assessment. In terms of the DPIA, we need a policy, we need a handbook, we need to train individuals on why we do a DPIA, what's the worst that is going to happen if we do not do it appropriately, and why different teams in the organization need to engage with this process. Now, at this point, jumping ahead, I've reached a stage with clients of mine where I'm saying, actually, have a DPIA policy, but I think the handbook is now an assessments handbook because it's covering all of these other items that I'm talking about. So what are all these other assessments that I am seeing right now? And apologies for the small print here, but we've got legitimate interests, which I've mentioned, privacy by design, which I've mentioned, data transfer risks, which I've mentioned, AI assessments, which I've mentioned, fundamental rights, which I briefly mentioned a few minutes ago. Now, recently, in the last few weeks, online safety. We have to think about, is our business doing things where we're caught by the Online Safety Act? Are we, by any chance, engaging with children? We would be if we are in social media, but we would be if we are a toy manufacturer, because we are engaging with children and so on and so forth. Accessibility, which I touched upon, how are we addressing that? If we are involved in the EU, we've got the equivalent of the Online Safety Act, which is the Digital Services Act. Cyber resilience. The government is in the middle of finalizing a cyber resilience bill because in the geopolitical world that we sit in, we have to think carefully about the supply chain and where we are buying in services or parts, etc., in our product. Are we comfortable that we have something which is technically, physically secure? I haven't put the DORA law, which applies to the financial services sector, in here. I could do, I probably should do, and I suspect in other industries, whether that's insurance or whether it's medical regulatory, there will be other risk assessments that are all intertwined with where I just started with in terms of privacy. This currently is the position when it comes to legitimate interests. The GDPR usefully stipulates some things where it is a legitimate interest, one of which is direct marketing. If you have an existing relationship with customers, it is a legitimate interest to be able to market your goods and services to them. If you are using technology to manage fraud, or you're doing background checks, etc., that is something where you do not need consent. Indeed, to tell somebody that you were doing it would be tipping off, so you wouldn't. You rely on legitimate interests, where you are sharing data in the course of a corporate reconstruction or organization. That is a legitimate interest, and where, again, you're using technology for network or information security purposes, that is a legitimate interest. So we are seeing more organizations relying on legitimate interest. 7th of May is the 3rd reading of our Data Use and Access Bill in the UK. That in the current draft, and I don't think it's going to change before we get finally to royal assent, specifically says that there will be legitimate interests specified by the government where you won't even need to do an assessment going forward, which is good for business. I'm not sure whether you might still want to do some sort of assessment just to dot the I's and cross the T's, but certainly consent is less valuable under the UK's proposals now. More will be able to be done with people's personal data without their consent, particularly when it comes to automated decision-making, sharing data, smart data. It's going to be an area that we will need to be focusing on, I think, as the law comes in. If you do go down the legitimate interests route now, you need to do that balancing test to genuinely show that on the one hand, what you say is a legitimate business interest is not outweighed by the rights of individuals. And even if you conclude that it is, individuals still have a right after the event to say, I do not agree with you and I object. So you need to have a process in the business that say, how do I manage these opt-out type scenarios? So I talked about privacy design. One of the other areas that has come up in the last 18 months is harmful designs or harmful online choice architecture. What we've seen with so many digital offerings is that you hit the website or you hit the app and you're presented with that usual pop-up that says, here's how much we love you and your privacy, but here's what we're going to do with your data because we use cookies or cookie-like technology. By using our website, you agree we can do what we want to do. And the Information Commissioner's Office in the UK, together with the Competition and Markets Authority, the Irish Commissioner, the Federal Trade Commissioner in the US have all been looking at key websites to see whether what they are doing is legal or illegal. And obviously the one that's in the press most recently is the big fine against Meta for the way they do their pay or consent, the take it or leave it approach. I thought it would be useful just to remind you what we are talking about here. Here is an example that the guidance from the regulator uses for nudging. So you hit the app or you hit the website and it says, we use cookies and similar technologies to provide a service that is fair and reasonable, and you have a choice. Do you want to control the cookies or do you want to accept? And you look at this on the screen, the control cookies is rather mediocre text color, but accept is bold. You are nudging, sludging individuals to go towards that accept. Another version of this is the confirm shaming. You hit the website or the app and it says, enter your name, email and phone number for a sweet savings deal, 20% off your entire order. And then the alternative to that is, nah, I hate savings. And the whole color, again, is driving you to go to give away something that you might not choose to give away. And the Competition and Markets Authority's interest in this is very much because they're saying some of the big players here are using their power and using their knowledge that most of us don't have time, don't understand, don't care, and just want to click the whatever button. But we've seen in the last year, the top 300 websites in the UK investigated by the regulator. A lot of the big media platforms, newspapers, etc., and it's caused them to rethink the way in which they engage, etc. And it's one where I wouldn't have been assessing this type of risk a few years ago, but we are now. And we need to engage with our marketing team or the third parties that we're using to build that app to say, how are you going to bake privacy first into what you're doing rather than creating something which is going to get us in trouble? The Information Commissioner says on this score, put the user at the heart of your design choices. Use designs that empower users. Why not do a pilot? Test and trial your design choices before you go live, see whether people are comfortable with what you are proposing, etc., etc. And remember that you need to comply with a number of different laws. It's not just data protection, consumer law, competition law, as I said earlier, accessibility law, fundamental rights, and so on. I mentioned international data transfers. Again, regulators, not just the UK, but China, now set out how you do a risk assessment where you are transferring personal data out of China to somewhere else. Saudi Arabia has got a similar approach. So this is not just us being awkward. This is happening everywhere. Do we know where we transfer personal data to? It's a really good process from time to time to audit your data estate. To ask yourself, do I know the provenance of the personal data that I have got in my system? We're finding that individuals now have learned that they have rights in relation to personal data. They have rights of access to know what it is you have got about them. They have a right of erasure to force you to delete their data. They've got a right of portability to move the data from your platform to another platform of their choice. They have a right to object. They have now a right to understand how AI is being used and to object to the use of AI, etc. Individuals think they have an absolute right. They don't. It's an interesting one that if somebody goes, now I know what you've got about me, that you scooped up by using a tracker without my consent, you will delete my data, is okay. But then some of the data that you might have about an individual you collected because some other law required you to collect it, like anti-money laundering. And if that were the case, you would go, well, I can erase this, but I will not erase that. And I've had situations where the aggrieved individual thinks their rights are absolute and they are not. So it's a great time for you to say, do I actually know what I've got? And what was the reason I got that set of data? And if you've got a good record of processing activities, that's where you would compartmentalize. In the old days, our customer relationship management software didn't have anything that allowed us to do that segmentation or compartmentalization, but we should be doing that. because it makes us better able to robustly fend off somebody who thinks they have absolute rights. If you know where the data is going to or coming from, and you need to manage the rights of individuals in that other jurisdiction, what is the tool or the mechanism you're going to use when you transfer the data? When we move data from the UK to another country, if it's not an adequate country, like I mentioned earlier, Japan, Israel, we need to think about some other solutions. So let's take the US. We could rely on the UK-US data bridge for transferring the data if the recipient company is signed up. If they're not, we might have to look at standard contractual clauses or the UK International Data Transfer Agreement. If the data is going in multiple directions or if going down a chain, how are we managing the downline position? There is quite a lot of drawing a line in the sand, as I said a little while ago, and going, woo, just before we press send, are we opening ourselves up to a world of pain? Is what we're using actually effective? So right now, that data bridge that we have from the UK to the US is somewhat wobbly. With the new administration in the US, where they've effectively dismantled all of the Democrat members of the Ombudsman that oversees the enforcement of data bridge, there is a question mark as to whether the bridge actually works. Max Schrems, who has been bringing legal claims against international transfer mechanisms, originally Safe Harbor, then Privacy Shield, is now saying we're going to do a Schrems 3 against this bridge and this privacy framework because it still is not worth the paper it is or it isn't written on. So you do need to just be comfortable that what you put in place actually works, or do you need some other supplementary measures or procedural measures? I've got a client who buys in a whole load of broker list details. They require their providers of the marketing lists to audit or be audited every quarter. It's a paper-based exercise, but they're basically saying when we gave you our business, you represented A, B, C, D, and E. Are you still doing A, B, C, D, and E? Or has something changed? Because if you're not living up to what you contractually agreed, the deal is off. They happen to be in a big enough to be able to make that demand. We need to think about that. And as I've said on here, part of the risk assessment is that you reassess. So just because you got something done 5 years ago, is it still worth the paper it's written on now? Back again to the other assessments. Yes, we probably do need, if we are using AI, no, start again. If we are using AI, we must do a DPIA. And probably now we need to be doing an AI risk assessment. And there are loads of models out there as to what that looks like. You're a sophisticated group of individuals in the technology sector. So I'm comfortable that you would be able to recognize when you are using AI or not. But when I am teaching my fellow notaries, we are very manual. We still do things with paper and wet ink signatures. But we are moving into a more digital world. And when I'm doing my training on AI, ask the room, hands up, who is using AI in their business? And few hands go up. And then I say, but let me give you some examples of where you are clearly using it and you probably don't even realize. What comes up when you do a Google search now? First thing you see is the AI summary of what you were searching for. If that's what you rely on, you are using AI. So hands up, how many people are you? And a lot more hands go up. And then equally, we are finding that some of the ChatGPT and other equivalents that are being used for creating documents or marketing materials, etc., people are inputting confidential information and breaching their codes of conduct, breaching client confidentiality. It's a scary area where you need to be sure, am I managing the risk? Before I started this talk, I was saying to Steve, I had an example not so long ago talking to a group of international lawyers about AI in the legal profession and the risks. And one lady at the back of the room from a very large American law firm said, we use AI regularly now in our document creations, in our due diligence, and we tell our clients that that's what we do. We have to tell our clients that's what we're doing. Some of our clients are now saying, well, I'm not paying that fee if the lawyer is not doing the work. Fair enough. But she said, we now have had a situation where we were doing work for one organization. They were in the middle of a merger and acquisition. We created the first draft of the acquisition agreement. We sent it to the client for their approval. The client decided to sanity check what we had created by running it through ChatGPT and put the corporate deal into the public domain. Breaching the confidentiality agreement, the non-disclosure agreement, I mean, almost killing the deal. And you think, one of the risks I've got is the people I am working with. I probably now need to think, how do I limit my liability? What do I need to talk to my insurers about? Do I educate my client what you do and what you don't do? And that really is quite scary. When we do our AI risk assessment, we do need to think about how are we managing the fundamental rights of individuals if the outcome of the use of the AI is that we discriminate against individuals. If we are forcing individuals to use a device or technology where, again, accessibility is an issue, have we assessed the risks there? Basically, there is a long list of different risks that you need to reach out and think about. And with AI, how's the algorithm being trained that we are relying upon? The training, could it lead to bias? Kick the tires on the proverbial machine. Consider the extent to which the past will predict the future. Will there be inherent biases? How do you compensate for bias built into the training? Make sure your AI projects are built into your overall governance structure. I put data protection governance, but frankly, it is data governance. Make sure you've done a DPIA to identify the risks, or as I said earlier, you'll probably now be doing an AI risk assessment. Make sure you've documented the who and the what and the where and the how and the why and so on. And then how will you address individuals' rights? There's a classic one. If you're using AI in your business and your customers' data is in OpenAI, albeit in a closed environment? What happens if an individual exercises their right of erasure or their right of access, but you don't have the ability to comply with that right? The law says you must, you're the data controller, but you've put that data into a third-party platform and they have it, you don't. So you're doomed to fail unless you have got something in the agreement with those third-party platforms that says you will cooperate with us and indeed the regulator if there is investigation. And I still think that human intervention is important. I talk about in my role as a lawyer that there will occasionally be somebody who comes to see me who is wanting me to identify them and to say, you are who you are, this is a genuine transaction, you are the chief executive with authority to sign on behalf of such and such a company. I from time to time will apply the sniff test. There's just occasionally somebody who kicks up a fuss about making available their passport. Or you've got their passport, but they've never signed it. That's where I apply actual intelligence, where I think artificial intelligence isn't quite there yet. And that's why I still think we need the human intervention and why we need to, if things go wrong, be able to say to, and I've said this several times, say to a regulator, we didn't do this lightly. Here's the thought process we went through, etc. And what happens next will be far less than if you had not got anything in place. I remember, again, just telling a story against myself in a law firm a few years ago. We had a situation where we inadvertently disclosed client information when we should not have done. I was being pressed by my finance team to get a particular client to pay their invoices. And it was a busy day, and I said to the finance team, just send me a spreadsheet with the details of the unpaid invoices, and I will send them to the chief financial officer in Manhattan and say, Ted, enough is enough, I need pay. So the spreadsheet arrived. I attached the spreadsheet to an email to Ted and said, re-outstanding invoices. Ted, you owe us 25,000. When are we going to get this paid? I'd like it by the end of the week. And a minute later, Ted rang me up and said, I know we owe you 25,000, not 12.5 million. Have you seen what you've sent me? It was only then that I looked at the Excel spreadsheet to see, to my horror, that the finance department had sent me the details of all of the clients that owed money. On the first page of the spreadsheet was a Formula One racing driver, an Australian supermodel, and a member of the royal family. Forget about the Chatham House rules. And I just, sank in the chair in disbelief. Ted very kindly agreed to delete the spreadsheet immediately in return for a further 3 months. Then I rang the lady in finance and told her what had happened, and she said, yeah, but it's all right, Ted's deleted it. I said, no, it's not all right, it's a breach. I now have to tell the ICO and I have to tell my regulator as a lawyer. A few weeks later, the investigating officers came to see me. We sat in a conference room, and the first thing one of them said was, oh, Mr. Bond, and you're an expert. Yeah. You have to remember when you are doing these risk assessments and you're trying to get your team to work with you that you are surrounded by idiots. Somebody will do something utterly dumb. And I think to myself with this spreadsheet issue, why would the lady in finance send me everything? I just wanted one client's data. And then as I tell this story every time, I think to myself, and who was the idiot that didn't look at what they were attaching before they sent it? If I'd have just drawn a line in the sand and just before I hit send checked, we wouldn't have had all of that. The good thing was when the guys were chatting was that we actually were able to produce the policies, the procedures, examples of the classroom training, the e-learning. So it was the risk, well, the outcome was not as bad as it could have been, but it was a lesson learned. That it just helps to just take that breath. And that's what the risk assessments are all about. So with that, I'm up to the end of my allotted time, and I'm very happy to take questions, Steve.
Thank you. Questions from the room, please, first.
No one else wants to go. Thank you. That was really fascinating to watch, really interesting, and very in line with some of the bits that I see all the time as well. And one of the things that we talked about recently in a CIO network event, but also we see all the time, is boards just don't understand the implication, and they're looking, and they are compelled to look at the bottom line and figures and the speed of a product going out, and that pulls them because of the shareholders and the drive. And they think it's not their problem. It becomes an IT problem, or it becomes a compliance team's problem, or it becomes the random person they put as a DPO who doesn't really know what he's doing and hasn't been given any training for it. It's just a name for it. How do we fix that? You know, does it need to be a legal? I know GDPR is obviously a legal obligation on the company, but do we need to make board members legally accountable to elements of this? And I would imagine they might be a little bit themselves anyway. Because it feels like, whilst we're making a bit of progress, we're 8 years on now, maybe 6 years on, 7 years on from GDPR 2018, and we're not moving very fast.
No, so I get asked this question a lot. The one way to get the board's attention is cause a data breach.
Yes, yeah. Well, the money's always there, and the willingness is always there after the attack, right?
But actually, I had a client where the legal counsel said, "Can you do? I need an opinion letter. Head it. What's the worst that could happen?"
Yeah, okay.
And one of them is that under the law, directors and officers are liable.
Okay.
There is a personal liability issue if the officer or officers do not follow or allow something to happen. And I think even in the last year, there has been, in the UK, the ICO has taken action against a director for simply turning a blind eye to things that were going on. So yes, there is a personal liability issue for directors and officers. There is the reputational issue. Turn it round the other way. I think I've had some organizations that have realized that putting all of the stuff in place actually enables them to market to other organizations. This is why you can use us. This is why we are a better choice than our competitors, because we're happy to open up and show you what we've got, etc. I do find now that, yeah, it's more of a C-suite issue than it used to be. I think data protection is up there with anti-money laundering, anti-competition, all of that, anti-bribery. It is there. And particularly as we're starting to see so many other parts of the world following, funny enough, the GDPR approach. So it's difficult to avoid it, if I'm honest. And it is business defining. You know, it could be, as I say to my profession, we are supposed to be trusted. And you might just be a small single practitioner doing notary work and you're not making much money, but this goes wrong, that is the end of your business, period. So it is worth making the investment. Okay.
I could add to that just for a second, Robert, just to reinforce the point that you'd just been making. I work for a company that works predominantly with the finance sector, so banks, building societies, et cetera, and I've noticed over the years that we've been doing the dreaded questionnaires that come in from institutions. In days gone by, they were always just security questionnaires. They were all about information security, cyber security. These days, they are in equal measure security related and privacy related, and the AI stuff's creeping in as well now.
You had your hand up first. Yes.
Thank you. Thank you for your great presentation again, as it was mentioned. I have one comment and one question. The comment back to the Manhattan incident. That was also a very good lesson learned. And so, you know, the other scenario could have when you type the email of the client, and either there is a same or similar name,
Yep.
or the email is very similar to, and there is an automation to you just inadvertently send out the email to someone else, so that would have caused a similar or even worse effect. That's very typical. I mean, it's always mentioned in
Yeah, autocomplete and so on. Yes, yeah, and then again, so when pre-GDPR, when the Information Commissioner had the ability to fine increased to £500,000, I said to our marketing team, we need to get a flyer out to our most important clients that the ante is being upped. Oh, we're too busy organising a polo match for our high net worth individuals. I said, oh, look, just give me the mailing list. I will do it myself. So I know that, of course, you put everybody in the BCC box. So I did that. I created a general email saying, just wanted to let you know the ICO has got increased powers to fine for breaking the data protection law. I created a flyer myself on my Mac with the fine details. I then added a picture of the scales of justice. It was about 20 some odd megabytes when I came to send it. And so it started egg timing. It was August, and IT rang me up and said, what on earth are you trying to send out? And I said, oh, yeah, no worries, I'll zip it. So I Control-Alt-Delete and I zip my attachment and I reattach it. And sure enough, it squeezes its way out of the building. Followed immediately by, because it was August, 1,000 I am on annual leave type emails. And IT is on the phone going, what on earth is happening now? And then my assistant, who was on the mailing list, it's about 3,000 people, swung round and said, have you seen what you've done? Everybody had dropped into the 2 box when I resent it. Yeah, so what did I do? Recall. No, just made it worse. And then about half an hour later, I get Mr. Angry from Isleworth ringing me up saying, who on earth are you to send my personal email address to all these other random people? I'm reporting you to the ICO. And I'm going, no, please don't. I'd forgotten that also on the mailing list was the ICO himself, who rang me up and said, Robert. And I said, yes, I'm so sorry. And he used that in a way, told that one against me. So, yeah, it's so easy to do. I did learn from that leave marketing to do marketing. And I'll just do the legal stuff. Your question, yes.
My question is that AI was mentioned in your presentation usually as a kind of caveat or kind of threat, and indeed in terms of all of the things you mentioned. But do you see any occasion or even more when we can use AI as a tool for improving compliance policy for data protection. So
Yeah, no, absolutely. I mean, I think there's no doubt that we could do due diligence swiftly if we'd got a reliable tool. Document creation, I mean, I have to say that you know, I played with some of the document creation. It's absolutely fine, provided you make sure you are not feeding the machine with things which are confidential, etc., etc. I can see, yeah, psychometric testing. Why wouldn't you be using AI to speed up the process to help you identify the right person for the right job, provided again that it is appropriately trained and so on. Yeah, no, I see loads of good.
or it occurs to me, for example, if we have to comply with different countries' laws, and maybe AI can be helpful because it's thousands of pages needs to be scrutinized. So with AI tool, maybe we can gather in what. Okay, it's a bit risky because sometimes AI can hallucinate. So it's another caveat. But in theory, it can exacerbate the processing to overview all of the different jurisdictions, laws.
No, I'm not against AI at all. I just think it is, we need to assess the risk,
Yes, I agree.
like with all the other stuff. Yeah, okay. I'm sorry, yes.
What an amazing presentation. You held my attention for an hour, which is absolutely unheard of. Thank you for that. A beautifully constructed speech too. I wanted to say, what does the future look like? What kind of feeling have you got? Is it all going to end up terribly wrong?
With privacy or AI or?
Yes, are we?
So, no, I feel quite positive.
You feel positive?
Yes. There are 170 countries now that have got data protection law in one form or another.
170
70.
countries. Oh, I see.
Huge. And many of them look just like ours, which is great for a multinational where you're trying to do a one-size-fits-all approach. Where I think we've just slightly gone backwards now is with the particular geopolitical world we live in, where there genuinely are concerns about where the data is going to. If you look at what came into force earlier this month in the US, they've said if you are doing bulk transfer of US citizens' data to countries of concern, that is an offence.
Uh-huh.
That becomes a real problem where your pharmaceutical that is moving a large amount of data because you happen to have an operation in China, which is a country of concern. Equally, China's doing the same thing in reverse. So right now there is a lot of money being spent trying to work out how do we stay legitimate when data doesn't really understand the law. Data is moving all the time. There's a lot of organizations like the United Nations, like the OECD, the Organization for Economic Cooperation and Development, that are creating or trying to put in place global conventions where, based on mutually recognized standards, data will move. I don't see that happening in this decade, but it might move to a point where actually it's a principle-based, and then we'll be able to focus on doing other things rather than having to run around filling in assessment forms and this, that, and the other. But I'm afraid that's where we are at the moment, is you need to prove when things go wrong that you were trying to do the right thing. So drawing that line in the sand, taking a deep breath and doing an assessment is just good practice.
Thank you.
Before we take any more questions in the room, I've just got a couple of comments and questions here online. The first one is very much related to what we've just been talking about. This is from Simon. And he says, I found one of the main parts of a recent compliance role, which I rather enjoyed, was convincing other people that compliance was important and important to get right.
Yes.
So absolutely reinforcing the points that you were making. Lindsay has sent a comment, not a question, but thank you very much. Fascinating talk. Lots of food for thought. There was a question from Simon. Quick question for Robert, please. Is there a decent mileage in a potential Schrems 3 future case, in your opinion, please?
There is still the threat that Max Schrems and the none of your business privacy folks will say the privacy framework does not work because the current administration doesn't appear to want to play by reasonable legal principles and will intercept communications, etc., and our rights won't be, or the rights of citizens won't be upheld. I think there's a fair chance that he would succeed. I don't think America will see that as a big issue because we've already got other things like the standard contractual clauses that allow the movement of data to flow. From a UK perspective, I think the UK government is running around, quite rightly, negotiating one-off data sharing agreements. So they're just doing an enhanced one with Japan because that's good for UK business. I think they would still do something with the US that would be useful for us, etc. But Max Schrems has threatened to do it. I still think there is the risk there. And then, the effect of the privacy framework was the EU saying to the US, we now think you are moving more towards an adequate country, but that was pre this administration. There are risks.
Just listening to your story about email, I'm sure we've all got a story to tell about email, if we're honest with each other. Many years ago, I configured a 1 minute delay on my outbox. The number of times it saved me.
That's amazing, isn't it?
Sits in the outbox for 1 minute and I have that, oh bugger.
Yeah.
And it hasn't gone, I can go and change it or at least check it and get myself to rights. We've had lots more comments and thank you online. I've just got a long one here that's popped in, so I'm going to see if I can summarize it. It's from Alan. He says, hello, Robert. You know, I enjoyed the bulk of my IT career with a company that has had that security and compliance as a fundamental feature of its operations and culture. Now I help individuals and small charities with cyber attacks and data breach and compliance challenges. I often find that a small charity is at the end of a long chain of companies outsourcing as they don't have the resources to extend the assessments. Are there any resources or costs that they can use to advise them to make sure that suppliers are offering the protection and accepting liability when such breaches occur? Alas, I find the big suppliers have been found wanting. Long question, sorry.
No, and that is a challenge. You're the small charity, you're up against a well-known big vendor. You don't have the negotiating power to say, this is what you will sign. You will be told, this is what we will give you. And I think, well, no, the regulator is realistic in those scenarios that you're probably unlikely to get the vendor to do entirely what you want. If they are the only choice that you've got, at least you should be able to show the regulator if things go wrong that you had asked questions, that you had pushed, even if you didn't succeed. So I still think that if you were looking to appoint another provider of services, you should have an approach where you go, here is the statement of what we want. Here is, you know, let's have a proposal from you that meets these requirements.
Yeah.
At least you can, again, you can show that you were trying to do the right thing.
And that, by the way, we all, I think, must. No.
Okay, thank you, Alan.
And Ian replied, Alan, have you looked at the NCSC guidance for charities? So if you're not aware of it, NCSC do have some good guidance on their website, mainly around the cyber, but also touching into privacy as well. So always worth a look. I've got nothing else online here. Do we have any more questions in the room, please? Hi.
Comment on your last point about smaller entities being a bigger required to make a change. I heard from a talk related to this topic a long time ago from one of the big four that in their experience that when they worked with Japan, actually the big Japanese companies made the point of actually talking with their SMEs, which was a different culture shift than what we expect, because we often hear, oh, you know, I was in the health sector, we go big, you know, pharma suppliers and like, no, and getting big suppliers to change something. So I just mentioned that is that there's some cultural that. The question I have is, I've done where we would have legitimate interest. And then in the case, if you would like to have information about our supplies and which is kind of marketing, then please opt in here. Can you explain what the difference is with that and the Pecker arrangement, where I understand that that's for marketing as well?
Yeah. So
Marketing thing?
the PECA rules or the e-privacy rules for the UK say currently that you can do a soft opt-in marketing to business contacts, but you can't do it to consumers. With consumers, it has to be with prior opt-in. The DUA bill is switching that now to say across the board, you can do a soft opt-in approach even with consumers, which is going to be even with consumers. So if you have sold to a consumer, then it is reasonable to be able to market further similar or same services, which is great. Charities are also going to be allowed to do the soft opt-in as well with donors, which they currently can't. I was talking about this earlier, well, on the webinar I was doing before I did this one. The difficulty is for some of the smaller organizations, if you're used to consent, then if you've got consent, you can show you've got consent. If you now move into legitimate interest, you've got to have another mechanism showing when people opt in or unsubscribe. Again, how do you manage that when you don't have resources? So some charities, I suspect, may not bother changing because it's just too cumbersome.
That was data use and access bill.
The DUA bill, yeah.
That's coming through this. Okay, thank you. That's quite important.
Any more questions in the room?
I was just a quick one, actually following from what Alan was saying, and you mentioned the small business element. Small businesses, large business has the compliance teams, has the people sort of a lot of time and more knowledge and the money a lot of the time to be able to put these pieces in place. Small business, even medium business in the UK, which has less data individually, but altogether has a huge amount of data, is now with this rise in SaaS, you know, they can just sign up to these platforms online. And most of them don't even ask the question of where that data is or what's going on with that. How do we, is that something we need to put back onto the companies themselves? Is it something the regulators can help with? Is there a way that we can address that at a national level? I don't really know. Or do we have to just keep getting those smaller companies, trying to get them educated in that way?
Yeah. So recently, the data that the ICO has fined a third-party processor for not meeting its obligations, because processors do have a liability under GDPR. When you look at the language in the Data Use and Access Bill, where we're going to see far more smart data sharing, they're saying data should be able to be used between energy companies, banks, insurers, utility companies with appropriate safeguards.
Okay.
You're not going to be able to object. That's what is going to happen, but your rights will be all right because there will be obligations on these people. I think we might find that the regulator will be coming after more of the big guys and saying you have to live up to standards to protect the rights of individuals. Well, we're not there yet.
No.
I still think that you need to have asked or done the due diligence questions, etc. And a lot of the reliable providers do provide white papers, frequently asked questions, because that's how they are selling their services, competing against their competitors. Okay. Good.
Brilliant. So thank you very much. Those of you here in London, we're going to go next door. I think there's a bit of food and a couple of drinks for us to carry on. I hope you're going to stay on here for a short time. So we can continue bombarding Robert with questions next door. For those of you online, thank you very much for your attendance. It's been lovely. There's been 25 odd people online listening and contributing questions to us. So thanks for joining us. And until the next time, good night and goodbye. And one final thing to you, we have arranged a token of appreciation access to the UPS online library for a year to the entire library.
Thank you.
Just as a thank you for coming along tonight.
Oh, pleasure. Thank you very much.
Yes.